to record. I'm so bad with that. It's recording now. So if you have any questions on that service provision that we offer, Poppy and Paya manuals, please give us a shout. You can either contact myself or Nicole. We can have a talk with you about that in our next webinar. We're also doing some training sessions, one-on-one consultations in regard to that as well. And then, of course, all our normal consulting, which I'm sure you all are very much aware of. So please feel free to chat with us during the webinar, after the webinar. I'll just put all of our details in the chat function as well. But Daniela, Willie, over to you when you're ready. Thank you so much for your time and preparation this morning. Willie Roos from Stratafin is definitely no stranger to all of us. And we're very excited to hear about the prescription of levies, whether or not it can prescribe and how that works.
Yeah, so thanks so much, Delinda. What I'll do is just introduce Willie to everyone, although I'm sure you all know him already from the webinars and from the industry. So Willie has practiced as a property attorney for over 20 years, been involved in sectional title management for over 8 years. Willie started Stratafin in 2014 with the goal of assisting corporates with their funding without catching them in a debt trap. Stratafin strives to be a fair and equitable money provider for the sectional title industry, and Willie has built up Stratafin from its inception to today, where it has debtors under management of over 300 million rand. Stratafin have also partnered with Medu Capital, and the PRC has invested with a 45% ownership. So over to Willie.
I think I might have accidentally muted Willie there for a second. Sorry, I was just trying to mute everyone. Willie, you can just unmute yourself.
There you go. Am I back? Thanks, guys. Thanks for the opportunity. I'm going to share a bit of information and my point of view in respect of levy debt with you guys, and explain why we believe that levy debt does not prescribe, but also a couple of other things that are very important and that trustees should know and note and take note of and utilize in respect of the collection of their outstanding levies. So the first thing that comes to mind is what is prescription, and we need to know what prescription is, and that is the legal principle in terms whereof a debtor's liability to pay his outstanding debt is extinguished or suspended after the passing of a period of time. What this means is that from the date that this debt becomes due and owing, if a certain amount of time passes and no action is taken for the recovery of that money, then the creditor will not be in a position to further enforce that debt and claim that from a debtor, which then can raise the defense of prescription against such a claim. So it becomes very important in the sectional title industry to know if a debt prescribes, because obviously if it does prescribe, there are less money that can be utilized for the upkeep of the scheme, and as such we need to know what the situation in respect of that is. I then have a little sentence there where I said that the above applies if the debtor did not acknowledge his indebtedness. Now that is one of the exclusions in the Act, where it specifically says that the running of prescription will be interrupted by an express or a tacit acknowledgement of liability of the debtor of his debt. So it is always important to keep all documentation in respect of a debtor's acknowledgement of his debt. So if an email is sent to the managing agent stating that I know that I owe this money, I can unfortunately not pay at the moment, I've lost my job, that tacit, that express statement that I owe the money has interrupted prescription, and prescription will then start running afresh from that period of time. So it's important that one keeps all of that at hand and know exactly what the situation is with those debtors. So there are different periods in respect of prescription. there's a 30-year period in respect of mortgage bonds. So if a mortgage bond is registered over a property and no payment is made, then that takes 30 years for it to prescribe. Any judgment debt, so once a judgment debt has been granted by a court of law, then that stands also for a period of 30 years and can be executed upon for 30 years. There are also others like tax and so forth, but those are not really so important in respect of us. Then a 15-year period in respect of debts owing to the state. So I was asked to discuss what the situation is with CISOS levies. I went through the act, and the only portion that I could get that could possibly deal with prescription in respect of CISOS levies is this portion where it says 15 years in respect of any debt owed to the state and arising out of an advance or loan of money or sale or a lease of land by the state to the debtor. So to me, I don't think it applies because it's not or a sale or a loan and a debt owed to the state. It is a combination of those two. So I don't think that the 15-year period applies in respect of CISOS levies. And then in respect of liquid documents, bills of exchange, negotiable instruments, we don't have checks anymore, so it's not so prevalent anymore in the market, but an acknowledgement of debt would also be a liquid document. So for those, it takes 6 years. So once a debtor has acknowledged his indebtedness in a document, then that takes 6 years for that to prescribe, and it gives the body corporate a bit of a longer period if the debt does prescribe, but we'll deal with that a bit later on, to then issue a summons and to proceed for the collection thereof. If one of these other periods are not applicable, and we can see that they are specifically not applicable because they are dealing with different things, then the Act says it will take a period of 3 years for any other debt to prescribe from the date that it becomes due, owing, and payable. And if you don't then collect, then that liability is then suspended, and it will be very difficult for a creditor to collect that. Not impossible, we'll deal with that a bit later on, but it is not cast in stone that you cannot collect that. All right, so why do we say that that levies are not, or levies does not prescribe? So let's have a look at what the Prescription Act says, and specifically section 13(1)(e) of the Act, where it says that if a creditor is a juristic person and the debtor is the member of a governing body of such juristic person, the relevant period of prescription would, but for the provisions of the section, be completed before or on or within 1 year after the date on which the relevant impediment referred to has ceased to exist. So what it says is that as long as a person is a member of the governing body of a juristic person, then until such a time as he is not a member of that juristic person, that levy debt will be suspended. If one have a look at section 3 of the Prescription Act as well, it also deals with that, specifically 3(1)(b), that says a person in favor of whom prescription is running is outside of the Republic of South Africa, alternatively is married to the person against whom prescription is running, or is a member of the governing body of a juristic person against whom the prescription is running. So section 3 also deals with that and says that for that period, prescription is suspended. I've then quoted section 15(3)(b) of the Sectional Titles Act, and the reason why I've done so is because in my mind, section 13, section 3(1)(b) and section 15(b)(3) all work together. So somebody can only unbecome a member of a body corporate once you have transferred your unit and the unit is no longer in your name. You become a member once the unit is transferred into your name, and you unbecome a member when the unit is transferred out of your name. So the unit can only be transferred when all amounts due and owing to the BC have been paid, or have been secured to the satisfaction of the BC. So you will then make sure that you get the payment after the transfer, the day or two after, by way of an attorney's undertaking or whatever the situation, or a guarantee, and you will then have that money. And that then releases the person as an owner, and then the person is no longer a member of the juristic person, and at that stage only the suspension will be uplifted. So as long as the person is a member of the juristic, of the governing body of the juristic person, then the prescription will be suspended. Okay, so what is a juristic person? I think the first thing that we need to find out is if a body corporate is a juristic person. So a juristic person has perpetual succession. It can sue and be sued in its own name, and it doesn't die when the member dies. So if one of the owners passes away, that body corporate still exists. It can sue in the name of the body corporate, can be sued in the name of the body corporate, and has perpetual succession as stated in the Act. So we clearly have to do here with a legal person. That was also found in the matter of Lorraine Reddy versus Body Corporate of Greenwood Village. So that is a judgment that I will refer to later on again. But in that specific case, the Pietermaritzburg High Court, it was a full bench of the High Court. Unfortunately, the judgment was never reported, but we do have it, and it still counts. The court has found that a body corporate is a legal person, and on that basis, they found that the debt did not prescribe. However, we will go a bit further than this. Okay, so we need to determine who are the members of the governing body. Is it the trustees, or is it the owners of the body corporate that are the members of the governing body? So I know that there are opinion that says it's the trustees. My opinion is that it is not the trustees, but it relates to the owners in general, and I will explain why we believe that that is the correct postulation of the Act. And we base our argument specifically in respect of Section 345 of the Sectional Title Schemes Management Act. So if we, Shirley, and here I'm grabbing your book now here on the side. If you have a look at Section 3, that deals with the functions of the...
Willie, you're muted.
Sorry, guys. If you look at Section 3, it says that the body corporate must perform the functions entrusted to it by or under this Act or the rules, and such functions then include. And then it deals with all the various functions, the establishment of the administration and maintenance of the administrative fund, repair, maintenance, the payment of rates and taxes, and so forth and so forth. So all those, I think there are about 20, 25 different things that is entrusted to the body corporate. And then 3T says, in general, to control, manage, and administer the common property for the benefit of all owners. So the right, all these rights and these functions are entrusted to the members as a whole. If you look then at Section 4, the additional powers, again, it is the powers are given to the members. And then in Section 7, the Act says that the functions and the powers of the body corporate must, subject to the provisions of the Act and the rules and the restrictions imposed or directions given at a general meeting of the owners of sections, be performed and exercised by the trustees of the body corporate. So all that has happened is that the Act says that these functions and the rights and the obligations are that of the owners as a general body. And then the trustees are just given the authority to act on their behalf, but in accordance with the directions as given by the owners and the restriction by the owners. So at the end of the day, the power still lies in the hands of the owners and not in the hands of the trustees. So it's very easy for a board of trustees to be stymied and stopped to collect levies. For example, a board of trustees must spend money in accordance with the budget that was approved by the AGM. If the AGM refused to approve a collections budget, so there is no money that is utilized for the collection of the debt, then there's a problem, because how will they pay? And if they do so, they are acting outside the scope and outside what they are allowed to do. So in that way, the owners can stop the trustees from actually collecting. They can actually put a direct restriction on the owners in terms of Section 7 and Section 5.1 of the Act to collect. Now, we have seen this in many, many buildings in the inner cities where the debtors become more than the paying owners, and at the end of the day, they take over the body corporate, and at an AGM, they vote against the collection of those debt. And that then makes it impossible for the trustees to actually go and collect that. And I think that is what the Prescription Act and Section 15 tries to cure and make sure that that doesn't happen. Because obviously, if that happens, then we have a problem that the body corporate will run out of funds, and we will see body corporates that owe millions of rands to the different cities and do not have sufficient money to actually recover that. That will mean that a special levy will have to be introduced to recover from all owners, even the guys that have paid, to now pay for the services that were enjoyed by all owners, even the delinquent owners. So I think from that point of view, it is clear that is the intent of the Act. I've had a chat to Prof. van der Merwe from Stellenbosch, and I don't want to name drop, but he was in agreement with the argument. I think they were 3 or 4 professors that discussed it, and I think out of the 4, one felt that it was only applicable in respect of trustees and not the owners in general, but the other 3 all felt that our interpretation in respect of the applicability of the Act was the correct one. Then in respect of case law, there's the matter of Santa Fe versus Besonia 407. It was a matter that was heard in the Pretoria High Court, if I remember correctly, and where the body corporate of Santa Fe proceeded with an application for the liquidation of Besonia 407. And the question then arose, does a liquidation stop prescription? And in that matter, the court found that it does not. It's not proceedings as required by the Prescription Act. And then they had a further look at the time period in respect of the debt, and they were saying in that matter that a 3-year period is applicable. If one reads the whole matter, you will see that there are various aspects that the court actually made mistakes on. There were judgments granted. It's clear from the Act that where a judgment is granted, that judgment stands for 30 years and you can recover on that judgment for a period of 30 years. The court missed that completely. The body corporate had judgments against the debtor. And then Section 3 and Section 11, which I just read to you guys and that we discussed, were never ever even canvassed in the court proceedings, nor in the heads of arguments. Subsequent to that, an appeal has been lodged. That appeal was the request for the appeal, or the right to appeal, was denied, but that is now been gone, or that's gone now further to the Supreme Court of Appeal, and we don't know what the outcome of that is yet, but it is hanging. In contrast to that, the decision of Lorraine Desiree Reddy versus the body corporate of Greenwood Village, where the full bench of the Pietermaritzburg High Court actually found that that Section 3 and Section 11 of the Prescription Act is applicable, and as such, all owners are members of the governing body of the BC, and as such, prescription is suspended until such a person unbecomes a member. So in our mind, that is the correct decision that was taken. We will, if this matter goes on appeal, then obviously the appeal court will have to look at the two different decisions, and then we'll have to make a decision which was the correct decision followed. We believe from our side that the correct one is that members who owe money cannot get away from it, and that they should pay at the end, because it will be to the detriment of the scheme as a whole if they are allowed to get away with the non-payment of their levies. Then I also said earlier on, the fact that a debt is prescribed does not stop the body corporate from proceeding. And in that regard, I specifically refer you guys to Section 17 of the Prescription Act that says a court shall not of its own motion take notice of prescription. So when a body corporate issues a summons and there is no defense to that summons, a court cannot step in as a defendant's attorney and say, but the debt has prescribed, and as such, I'm not going to allow this judgment to go through. So in practice, and I think Rudy is also on here, Rudy Heerschop, and he can confirm, they one of our panel attorneys, we proceed and we issue summons and we take judgment, and we have never had a problem where the courts then have said, where they've moved from their own accord to say that prescription has taken place. So from that point of view, it is important that trustees issue summonses as soon as possible. Obviously, you want to do it within the 3-year period. You don't want to wait, because we don't want to find ourselves when the Supreme Court of Appeal makes a decision on the wrong side of the law. So we want to issue summons as fast as possible. But also where we have gone over that 3-year period, it does not stop you from doing so. Go ahead, issue the summons, and deal with the consequences of that summons or the defense in respect of that summons if a defense is brought up. From our point of view, I mean, we've got thousands of debtors that we deal with, and we see that less than 2% of those that owe money to body corporates actually defend the matters. So the chance is very good that if you issue your summons, that you will actually get your judgment, and the matter will be then, you can then proceed with the matter, proceed with the attachment of movables, thereafter declare the immovable property executable, and proceed with the collection of that. So yeah, so that's my opinion in respect of prescription. I hope that makes sense. I hope I've explained myself, and the basis on which we believe that prescription is not applicable. If anybody wants to ask a question, I'm more than willing to try and assist. I don't know if I will, but luckily we've got lots of experts on here.
Willie, we've got a question in the chat function. It's, can the debtor then apply to rescind the judgment if they raise that there were parts of the amount that have prescribed?
Yes. Obviously, if a debtor applies for a rescission, he has to show that there is a bona fide defense, and he has to show why he did not defend the matter initially. So those are the two legs that would apply. I would think that courts are very slow not to grant rescissions. We see in practice that even if there is no defense and the debtor comes to court and he raises something that he might think is a defense. For example, they say that the roof was leaking and it caused damage to my unit, and as such, I was entitled to set off that amount against the amount of levies owing. Then the courts, even under those circumstances where the act is clear that a debtor cannot do that or an owner cannot do that, the courts still grant rescissions of judgment. So you will probably get that a court will grant a rescission, but then will go through the whole process. I mean, the matter will have to go on trial then. Evidence will then have to be led. And we've discussed in a previous seminar where payment is firstly utilized in respect of the oldest debt. So one will then go and have a look, what was the last time period that a payment was made? and see, because the moment that payment is made, then that is a acknowledgement that the amount is owing, and as such, then that stops prescription or suspends prescription for that debt. So one will go and have to investigate that, and you will bring all of that evidence in front of a court until we have legal certainty in respect of this. So I can tell you that, I mean, what I've said is my opinion. It's not legal certainty, because we do have two different cases. One that says it does prescribe, but not taking into consideration all the factors, and then a case that says it does not prescribe. So we don't have legal certainty currently in the country, but our opinion is that the courts will at the end understand why it is necessary to suspend prescription as long as you are a member of the governing body. So I think that's the answer.
Ask a question?
Yes, Paul.
Sure.
I just want to check them, because a couple of months ago we had a CSOS ruling where we took one guy to CSOS for outstanding levies, and they came back and said, yeah, but we must adjust the amount claimed because part of the debt is prescribed. Can we go to CSOS actually now and object to that ruling, because saying they erred in law because the debt does not prescribe?
Definitely. Well, the question is it a question of fact or is it a question of law? I mean, that is why I, on the groups, warn against taking matters to CSOS, because a decision on fact is not appealable. I know that CSOS wouldn't like me to say that, but the fact of the matter is that it becomes very difficult if you have a commissioner and they make a decision on fact and uses the wrong facts, and you can't appeal that. Then you as a body corporate have a problem, and that impacts all other owners. So in my mind, it is always better to go to a court, take it through the court process. It does cost more, but at the end of the day, you know that you're going to be able to appeal if the wrong decision was granted. The law specifically states in section 17 that the court cannot take cognizance of prescription by its own accord. So I would think that that is a legal argument, and as such that it is appealable on that basis, and then to take it to a court that then must make a decision in respect of that. I think it's dangerous to take matters to CSOS. We don't. I mean, we take it through the court process because we believe that it is a better process. It might be a more expensive process, but we know that the court process works.
Okay. Any other questions? You're more than welcome to ask them now. Alternatively, put your hand up or pop them into the chat function. Perhaps some practical examples that you've dealt with in your schemes or your managed schemes. I know that we do have Rudy online. Rudy, do you perhaps want to give some of your practical experience in court, some comments there?
Hello, everybody. Yes, I just want to start off by adding what Willie said with regards to the question posed with the decision of judgment application. So what normally happens is we will attend to the collection matters through the Magistrate's Court. Now, when we deal with the Magistrate's Court, and as soon as we have a judgment there, when we faced with the decision of judgment application, especially with a technical legal argument, we seldomly see strong magistrates coming out and addressing the actual issue. What they do is they move it to the side and they refer it to the trial court. So because we're dealing with this legal uncertainty, especially with prescriptions, we struggle to get magistrate who are strong, who are willing to address these issues and make good judgments on the matters like this. But normally we will then, as soon as we faced with a matter of this nature, we will then agree to the decision, but then we will place the actual defendant on terms. We will then provide them with deadlines for their plea filing, which will then again apply for judgment. Alternatively, we'll bring an application to strike the defense. So there's a lot of ways in skinning this cat, but you just need to be clever in the approach that you take. But yeah, we do have some difficulties when it comes to magistrate actually wanting to hear these arguments when we deal with the decision of judgment applications.
Fantastic. And Rudy,
Yeah, I can just add in respect of what Rudy has said. I mean, even an application in terms of Section 66, where you apply to have the property declared executable, we find that magistrates do exactly the same, kick for touch. They don't want to grant those orders, and they would say, no, please proceed with Section 65 first. So do an inquiry, find out what the debtor can pay, and then they make an order where the debtor pays on a debt of 50 or 60,000 rand, 50 rand a month or 100 rand a month, which obviously does not help anybody because the interest exceeds the amount that is payable. I mean, obviously at some stage in Duplo becomes applicable and the debt runs up to double the amount of the capital amount because the courts are slow to grant Section 66 applications. So it's very difficult where the courts don't apply the law and do what they are there to do. And we see that, but there are ways to get past that. I mean, obviously one can move matters from the Magistrates Court to the High Court, and we find that things go easier in the High Court, but there's a cost implication to that. And that is why legal collection matters become so expensive. I mean, we've seen matters that have gone up to sale and execution where attorneys have charged 120,000 rand up to that point. You can probably recover from the debtor about 25,000 rand on a party and party tax scale. So the other owners are then liable for that additional 100,000 rand because in terms of the rules, you can't recover that from the debtor. You can only recover the agreed fee or the taxed fee. And that is why it becomes important for somebody like Zerlinda to actually change the rules, make sure that you can recover the full amount of legal costs from the debtor and not from the paying owners. Otherwise, it becomes a very large burden on the paying owners.
Bobby, you've asked on the chat if you could pose a question. Please go ahead.
Thank you very much. The problem that I'm facing is I moved into our complex about 2 years ago and realized from the outset that there was huge problems with the way our scheme was run. And I took it upon myself to start setting matters to get it okay. It's been a long process, but we're taking baby steps, but we're getting there. The question that I've got is, I've got an owner sitting in New Zealand and owes money since 2017. Now there's a bond over the property and the bank has taken sale, it's going to sale and execution.
Yeah, just take this.
The question I'd like to know is, where do we stand if the mortgagee cannot find a buyer for the outstanding bond stroke costs and fees and all that? Where do we stand as the body corporate?
Okay, so firstly, you are covered in terms of Section 15 of the Sectional Titles Act, Section 15B3, where it says that property can't be transferred until all amounts have been paid to the body corporate. So if the bank if the bank buys it back itself as a property in possession, then they will have to pay the body corporate to get transfer. Otherwise, they won't get transfer. If the bank decides not to sell, and they decide to just leave it, then obviously they're also not going to collect their money. But in all probability, what will happen is you will get hijackers, because we see that most of the sales in execution are frequented by hijackers that buy these units and then put tenants in there, and they then collect the rental income because they're entitled to occupation from the date of the sale. They will then collect the rental income, and in a year's time, the bank will cancel, and the hijacker would have lost 10,000 rand or 5,000 rand in respect of a deposit, and the process will start over and over and over again. So that is a problem. That is a real problem, and we at Stratafin deal with those sort of things. I mean, we've got hundreds of units that have the same problem, and we have mechanisms that we deal with it. So I would think that maybe get in touch with somebody that knows and understands what to do next in respect of that would be a wise option.
Well, because at the moment it's in the hands of our attorneys, but they just sit back and say, right, you should get your money. because we are preference creditors as well as the municipality as far as rates and taxes are concerned. But your hijacking situation does pose a bit of a concern to me.
Yeah. And that will happen. I can tell you now that 99.999% of all sales and execution that takes place through the sheriff's offices, it is hijackers that purchase these units. I mean, we know them. We are there on a weekly basis. We know them by name. We know who the kingpins are. And unfortunately, the sheriffs don't mind, because they get paid their deposit at the fall of the hammer. And if the sale is cancelled in a year's time, or 8 months or 9 months' time, then the property comes back on the market, and the same thing happens again, and they get their deposit again. So it's a problem. I mean, it is a problem that we need to deal with. I've requested the Sheriff's Board for an interview that I can speak to them and see if we can't resolve this, because it is a problem that one needs to deal with.
Okay, Willie, thanks very much for that context.
Shirley, before we take your question, we've got one question on the chat function from Jan. What do I do with a conveyancer who one-sidedly decided to arrange transfer of 2 properties without a clearance certificate, claiming prescription applied, loss to body corporate exceeds 200,000 Rand, false declaration of the deeds office is laughed off as a slap on the wrist?
Okay, so there are 3 different things that one would do in general, I would think. Firstly is to lay a complaint with the Law Society and proceed with that, and make sure that you prosecute that, because a conveyancer needs to file a certificate in which he states under oath that the amount was paid or it was arranged to the satisfaction of the body corporate. So that was false. So that will be a problem for that conveyancer at the Law Society, so you will have a problem with that. Your second option is then to institute action against the conveyancer and the Fidelity Fund and his insurance in respect of the loss that you have suffered. And the third option is to make use of Section 6 of the Deeds Registries Act to cancel the sale. So one would then apply to the High Court for the cancellation of that sale. And the moment that the High Court cancels it, it goes back to the previous owner's name. And then the purchaser that bought from him obviously then has a loss, and the bank has a loss, but that's their problem. They need to deal with it the way that they need to deal with it. We're currently going through one of those. In this instance, the debtor got a friend to act as the managing agent and issued the figures. The money was paid by the conveyancer to the friend's account, and on the same day, the money was repaid to the debtor's account again, and the conveyancer proceeded with transfer. We did investigate the possibility to proceed against the conveyancer in this instance. In this instance, the conveyancer is saying that she did not know, and she could not reasonably have known that this was false. So we have decided to leave it there, and we've proceeded with the Section 6 application, and we've been successful with that, and the property was transferred back to the debtor's name. So that are your options. That's your options in respect of that.
Thank you, Willie. Shirley, you had your hand up. Just unmute yourself.
Can I have another question, please?
Willie said just now that we should speak to you about changing the rules to say that you can recover the full amount of the legal costs from the owner. Is this what Willie meant? And can you change the conduct rules for that?
Unfortunately, not the conduct rules. That would be way too easy. It has to be in the management rules, because the management rules deal with the collection. So you'd basically be reverting to the old management rule 31.5, dealing with the recovery of legal fees.
Okay.
We have actually been getting quite a few instructions of late to amend the management rules, but obviously body corporates really battle with the quorum requirements for that meeting.
Okay, thank you.
But obviously, if you don't get a quorum, you can still go to CISOS and you can apply that they then still amend. Am I right, Zerlinda?
We do that. We've done
correct
those applications where you make a direct request to the Chief Ombudsman. So it's not an application for dispute resolution. It's an application in terms of Section 6.9 of the Sectional Title Schemes Management Act for a special or unanimous resolution. We haven't had a lot of joy with regards to the timing of it. It takes a very long time for the Community Scheme Audit Service to come back to us on those. And in some instances, the body corporate does try to have another special general meeting or tries to pass the resolution via round robin. We have started getting those types of outcomes from the Community Scheme Audit Service. In some instances, they refute it simply because of the number of owners that have voted against it. And other times they deal with the actual comments that the members send through to them. So it's been very interesting to deal with some of those outcomes, but it's definitely an option. You've got a question from Glenn, if I'm spelling it or saying it correctly. Do the 3 steps have to happen in a sequence, or can it be done together? I'm assuming that's with regards to the conveyancer.
Yeah, no, you can, obviously you can do that at the same time. You don't have to wait one for the other. I mean, they're all 3 different steps that you can take and that you would take to try and recover your money. Try and make it as difficult as possible for the conveyancer. Issue that summons, proceed with your application in terms of Section 6 of the Deeds Registries Act, and do all of them at the same time. I just saw Yapi also ask if I know of hijackers in Newcastle. Yapi, we do know of a syndicate that operates in the whole KwaZulu-Natal. So yeah, we have to deal with them the whole time in respect of these sales in execution.
All right. We've had a couple of guys that have left the session in the meantime, but have popped me private messages to say thank you very much, Willie, for the content of the presentation. Just a reminder, the session was recorded and the recording will be made available on our website. We will also be sharing the presentation via email. And then, of course, if Stratafin wishes to send anything else, we will forward that as well. If you've got any questions that you'd like to ask offline, I have popped through Daniela and Willie from Stratafin's email addresses, as well as a link to their website. And then, of course, Nicole and myself, our contact information as well. There's a comment from Tertius. Hi, Yop. Yes, I've had personal experience of that in KwaZulu-Natal. Quite interesting. I've never referred to them as hijackers. I normally refer to them as the people with the baseball bats. But either way, I think it's the same outcome. Do we have any final questions before we head out back to the office and back to work this morning?
Yeah, can I ask one, Celinda? This is Daniela or Willie. Do you take on ad hoc debt collection, or is it only in terms of what you are actually processing or working with?
Yeah, it's only what we process. So yeah.
Thank you. What a pity. This was so interesting.
Fantastic. Ladies and gentlemen, thank you very much for your time. To Willie and Daniela, thank you very much for your time in preparation. Of course, attending and speaking at the webinar today. It was definitely very informative. If you do have any questions, you're more than welcome to stay behind. Otherwise, please keep an eye out on social media as well as our website for the recording. Thank you, everybody. Have a lovely day further.
Thank you.
Thank you.